Just before my connection went off, we were looking at the made-up question with respect to how the internet or technology, so to speak, has affected formation of contracts in Ghana. And I was making the point that having explained in brief what the usual requirements of the law at common law with respect to the making of contract, especially how you establish agreement, offering acceptance, and all that. You need to discuss aspects of the Electronic Transactions Act, especially how it impacts on things like communication of acceptance, okay? And so, I mean, that is the, if we like, some of the relevant provisions. So you can, but if you haven't looked at the Electronic Transactions Act, I would advise you to look at the section 18, section 19, and then look at section 22, section 23, and section 24, which have got provisions which to some extent modify the usual rules we have at common law concerning the making of contract. So let us pay attention to that. And of course, we also have what we call like the automated transaction section 17. I would also like you to pay attention to section 17. If the transaction is automated, how does the law actually determine the relevant dimensions of it? So for example, if you look at section 17 of the Electronic Transaction Act, we'll be told that an automated transaction is valid even if an electronic agent is involved at any stage of the formation. So that is to say that it is possible for all that we know about, offering acceptance and all that to take place without direct intervention of a human being, and all that can take place electronically through automated system, just like what section 17 of the legislation is reminding us of. That quote, a party interacting with an electronic agent to make an agreement is not bound by the terms of the agreement unless the terms were capable at first of being assessed by the party prior to the formation of the contract. Okay, so we are giving a specific rule that yes, if you are dealing with someone through the electronic means, then before the terms will be binding upon you, you must have had the ability of assessing it. Assessing it means that you should have been able to open it. So just as online, you're doing a lot of things and they will give you the requirement, click, agree, or don't agree. So that is the kind of thing section 17 of our Electronic Transaction Act is alluding to, that where you are taking part in a transaction through such automated system, before you are deemed to be bound by the agreement, you must have had the ability to assess. To assess means that to see. And that does not mean that to have it in hard copy, no, but be able to see it. And usually you have like a checkbox, for example, which you may have to click to signify that you have actually assessed the terms and conditions, as it were. So please, if you haven't looked at the electronic transactions Act before, as I have said, the relevant provisions that we need to look at are not many for purposes of contracts at this stage. So section 17, the automated transaction, look at it. Section 18, dispatch of electronic record. And that is what has implication for, at what point can we say that acceptance or offer has been sent? So if we look at section 18, for example, we are told that unless otherwise agreed between the originator and the addressee, the originator is the one who is sending the information, and the addressee is the person to whom the information is being directed. Unless it is previously agreed, the position of the law in terms of section 18 of the Electronic Transaction Act is that the dispatch of an electronic record occurs when it enters an information processing system outside the control of the originator or the agent of the originator. So let us keep that in mind. So therefore, if you are given maybe some sort of facts, like in a problem-based question, and you were told that maybe somebody emailed a letter of offer, a letter of acceptance, and you need to work out the timelines when the contract is supposed to have actually taken off. You should be able to remember section 18 of Electronic Transaction Act. And then 19 also talk about the receipt. That is when you can say that the thing which was sent was received, right? So how do you determine the time or the date for receipt? So section 19 will tell us, among other things, as follows, that the time of receipt of an electronic record shall be determined as follows. A, if the addressee has designated information system for the purpose of receiving electronic records, receipt occurs at the time when the electronic record enters the designated information system. So for example, if you are dealing with, let's say, fax, right? Fax machines and emails and so on, and you need to determine when a person can be said to have, let's say, received the letter accepting the offer or revoking the offer, as it were. You must find out at what point did that letter or that mail enter the designated information system. That designated information system means that the system the person has subscribed to as a means of receiving electronic communication, as the case may be. So for example, if it's email, it's not when you read the email, which will be the decisive moment during which you actually receive the particular transaction in terms of being an offer or being an acceptance. But when it actually hits your server and entered your inbox, let's put it that way, then you are said to have actually received it. Just as if you send it when you go to the sent, if you like, a message, the time that it was deemed to have been sent is when it left the electronic, the designated information system under your control. Now, if you look at 19B, it also says that the time of receipt is determined if the addressee has not designated an information system. Receipt occurs when the electronic record enters an information system of the addressee, through which the addressee retrieves the electronic record. So that, for example, refers to the email, okay? So the first scenario refers to things like fax and things like that. But this one, the second one, 19B, will mainly be like the email and probably WhatsApp and all that, because it works in a very similar fashion. So let's take note of that. And then in terms of the place, if you remember the case of Entos versus My Far East Corporation, Entos versus My Far East Corporation, where Danny LJ and his brethren had to work out whether the contract took place in London or took place in Amsterdam, if you remember that particular case. Now, in Ghana, our Electronic Transaction Act has provided its own solution to that kind of problem. And that is in the shape of Section 19, subsection 2, right? So Section 19, subsection 2 says, and I quote, an electronic record is deemed to be dispatched at the originator's place of business and is deemed to be received at the registered place where the addressee has its place of business unless otherwise agreed by the originator and the addressee. So Section 19.2 effectively clears the doubt, the difficulty, the conundrum, which was encountered in Entos against My Far East Corporation. So Section 19.2 is saying that we have certain rules of thumb, and the rules of thumb are that if we are talking with respect to the originator, right, the person who is sending the information, then as a general rule, the originator is said to have sent the information from where he is, right? From where, not from where he is, from the registered place of business. Let me correct myself. From the registered place of business, not where he is. So, for example, as we speak now, we have, let's say you don't know where I'm speaking from, right? You don't know whether I am in Ho, I am in Tamale, I am in Takoradi, Accra, Kumasi, or wherever, okay? But let's suppose that my my registered place of business is, let's say, Tamale. And I have to send, let's say, an offer or my acceptance. Then if we need to, when it comes to litigation, okay, when it comes to litigation, civil procedure, if you are determining what you call like the venue or the place, the forum, where you can sue someone in respect of a transaction or contract, among other things, you need to find out where the contract was made or where the contract was supposed to be performed. And that is where it becomes necessary to know the place. Because at common law, the contract is said to have taken place at where the acceptance occurred, right? So that if you email the contract from O, and let's say that I accepted it in Kumasi, and if we are going by the provision of the Electronic Transaction Act, which says that where the information leaves the information, the acceptance leaves the information system under your control, you are deemed to have actually sent it. Then it will be that when it leaves wherever I'm sending it from, I have actually sent it. But that may create confusion, and that is why the lawmaker, in its wisdom, per Section 19.2, is saying that where we are dealing electronically, we have some general rules to determine the place where a person is said to have sent information or transaction from. So that if you are the sender, that is the originator, you are deemed to have sent it from your registered place of business and not where you sent it in fact. So let's say that if my registered place of business is Kumasi and I am in Tamale and I had the internet there or whatever, and I sent, I emailed something while in Tamale. For purposes of the place where I sent it, Section 19.2 is saying that the general rule is that since Kumasi is my registered place of business, it will be used as the place where I send the information from. Of course, this is the general rule, and it is a rebuttable presumption. You can bring evidence to show that despite the fact that here is a registered place of business, the information was not sent from there. So let us take note of that. And the same thing also applies to the addressee. Addressee is a recipient, okay? So therefore, if you are a prospective offeree, you have sent your email of acceptance, the offeror become the addressee, right, for purposes of the mail containing the acceptance. And we want to know where the acceptance, for example, took place. Then the general rule applies that it is deemed to have taken place at the place of business, the place of business of the person who is supposed to receive or who is supposed to send the information. So let us take note of that. So you notice that if you have these basic provisions, you'll be able to actually put some ideas together, assuming you get like a general question. For example, asking you to make a presentation to a business community, right? Or to some business students in a business school, telling them how technology or how internet has affected the law relating to making contracts and so on. Among all other things you'll be talking about, you shouldn't forget the Electronic Transactions Act. And therefore, if we look at section 23 of that legislation, which addresses formation and validity of agreements, it has a very useful provision to the effect that, quote, an agreement is valid even if it was concluded partly or in whole through an electronic medium, okay? So section 23 of the Electronic Transaction Act is telling us that it is perfectly acceptable in law for you to use the electronic medium to conclude agreement, either wholly or partly. So let us keep that in mind. Yeah, then if you want to, if you want to read the law more, you can also look at section 25 and 26 with respect to transaction involving governments. But otherwise, if you know the 17, 18, 19, 20 up to, I think, 23, I think that should serve you well. And the same thing applies when it comes to variation of agreement between parties. So section 24 makes the point that all the things we know in relation to formation of a contract are also applicable to variation. In fact, if you have time, I will encourage you to start from section 5, okay? So read the whole of section 5 to section 24. Because if you read section 5 to 24, you get the complete picture, and especially where a signature is required. Because mind you, talking about contracts, we are not only talking about simple contracts, we are also talking about all contracts. Contract which requires signature. According to the Electronic Transaction Act, that can be done. You can have what you call like a digital signature, okay? So if we take section 10, for example, a digital signature, where a law requires the signature of a person, that requirement is deemed to be satisfied in relation to an electronic record if a digital signature is what is used. So please look at section 10. And that is why I said that to play safe, start from section 5 and read up to section 24. And then you will be in a position to have a complete picture regarding how the electronic transaction law has impacted the traditional rules on contracting. Is there any question on that before we move on? Okay, so after this, is there any question on offer and acceptance? Because we are moving from that area. As I said, I don't intend to take you through any particular topic in contract unless you raise up issues and questions. Because if you look at my previous videos on the Ghana Law TV, you notice that I have covered almost everything in contract. So there's no need for me to repeat myself. Just go there and look at the previous recordings. However, since I am here, you have the opportunity. If there is anything particular you are not clear about, just bring it up and then we trash it out. Okay, if you are not bringing anything on offer and acceptance, let's move on to consideration. Any question on consideration or anything about consideration you are not clear with?
Yes, please, my lord.
All right, Richard.
Consideration regarding the use of electronics like internet. What is the law of the Act of Electronic Transaction Act treating it? How is it treating it?
So how does the Electronic Transaction Act affect consideration? Is that it?
Yes, execution of consideration, please.
Oh, okay. All right. Thank you. So to start with, we have to remind ourselves of what consideration is. And as you know, the general position of the law is that we have two types of contract: simple contracts and then specialty contract. Specialty contract is also known as contract under seal or contract by deed. And the position of the law is that where you have you have a specialty contract or contract under seal, the contract can be enforced without the need of showing evidence, right, of consideration. It can be, and the reason is that the parties have got their seal on it. And historically, if you look at seal is supposed to be your official mark of approval or authentication, that you stand by what the document is what it's saying. And that is why if you have your seal on a contract, the contract could be taken at its face value without the necessity of anybody trying to show that he or she did anything to justify why you are being held to that contract. And that's what we call the consideration. But where the contract is not under seal, what it means is that it is a simple contract, which may be in writing, and even being in writing, it may not be a requirement for signature of the parties and so on. Or even if there's a requirement for signature of the parties, it may not be their seal. Or it may be just by word of mouth, right? In which case, it's just like a parole contract, also a simple contract. Now, where it is just simple contract in the way that I've explained, we have evidential difficulties because it may well be that there was no such contract, okay? And one person is just trying to play fraud on another and get the court to help him to get someone to perform something he or she has never agreed to. And that is why the law developed that where the contract is simple, parole, that is oral, or just in writing, but does not require the seal of the parties, then the courts need to be certain as whether there was such a transaction. And that is why the party who is seeking to hold the other to it, seeking to enforce it, will need to provide a reason. We need to provide evidence of the reason why the other party made such a promise. And the reason why the other person made such a promise is what has come to be known as the consideration, right? So that is what we call like the element of exchange in the promise, or the bargain element, or something in return for something. So if you can show that probably because you perform another act or you paid money or you did something, that is why he also did this, then the court is satisfied that you are not just making up a story, right, against the other party. So consideration is essentially, a matter of evidence to try and establish whether, as a matter of fact, a certain promise was made, a promise which does not have the seal or the deed of the other party, as it were. So therefore, when it comes to electronic contracting, coming back to our friend's question, is consideration still necessary? Is consideration still necessary? Okay. Now, insofar as the Electronic Transaction Act, for example, has not addressed the issue directly, we need to read the Electronic Transaction Act together with the Contract Act together. And we say that if, for example, there was a need for a signature, right? Digital signature. Then the digital signature and all that will be enough evidence that there was such a promise or agreement between the parties. And for that matter, they meant to do whatever that they agreed. And that will be enforceable, even if consideration has not been provided. And don't forget that as a result of the modifications to the Common Law Doctrine of Consideration by our Contract Act, Act 25, way back in 1960, consideration has had a very reduced role or reduced function in the making of contracts. So don't let us forget that. And also remember Section 26 of the Evidence Act, what you call like the estoppel by conduct, right? Where you make a statement or anything and you create a certain impression, and then the other party act upon it, then you'll be stopped by the statement or by that particular conduct. So therefore, where I have sent, let's say, an offer to you, requiring you to accept it, and then you have used your electronic signature to accept it, and later on when you are held to it, and you say that you never agreed to any such arrangement, Section 26, for example, will come in, and then you'll be stopped. And where Section 26 and all that applies, there's no need for consideration. So let us keep that in mind. Okay, any other question on consideration before we move on? Okay, maybe just to remind you, if you haven't adverted your man, as far as Ghana is concerned, contract teachers or lecturers will never teach consideration, and for that matter, examine consideration without testing students' knowledge of the modifications which have been made to the common law doctrine of consideration. And on that, it's very straightforward. Mrs. Zona Harmon has a nice article. Almost every student of law of contract in Ghana has come across it, also in her book, or otherwise, you just know the common law rules. For example, when it comes to sufficiency of consideration, a lot of changes. At common law, we are told that when it comes to varying contract, right? And for example, a person has an obligation under an existing contract, and he, for example, that contract is varied as to whether the obligation you have under the existing contract, if you perform it, can it be a consideration? Just like what happened in the, what do you call the silk and marriage type of cases. Remember the cement case. There's a contract between them and the master of the ship that they should work on the ship, complete the journey of the ship. That is a voyage. And in the course of the travel or the journey, some of the workers, for example, deserted the ship, and the master of the ship wanted to motivate the remaining crew and promised to pay them extra wages should they complete the voyage, the journey. The voyage was completed and he didn't pay. So the remaining seamen sued him for the extra wages promise. And question is whether they had provided consideration for the promise by the captain or the master of the ship that he will pay extra wages to them. And they said that, well, yes, we did extra work. We did the work which we are supposed to do plus work which the other runaway seamen were supposed to do. So that is consideration. The common law was that no, since it was already your duty to do that, what you have done will not be regarded as sufficient or as a good consideration, right? Still can marry. But then if you come to our own contract act, we have a provision that where you have performed a duty under existing contracts, right? You have existing legal obligation, be it the existing contract or existing statutory obligation, that will suffice as a consideration. That will be a good consideration. So let's take note of that. Any other question? Of course, about consideration, you should also remember the part payment problem, okay? When you say the part payment problem, still an aspect of variation of contract. The well-known penal, the rule in the penal case, if someone is owing you a greater debt, and you promise him that if he will pay a lesser sum, you forgive the rest of the debt. Are you bound by that promise? Or you can go back and demand the rest? The common law, as we saw in the penal case, first and B, was that so long as fresh consideration are not be provided, you couldn't go back and actually, I'm sorry, you could go back and demand the other part you said you not demand, unless fresh consideration have been provided. And of course, you saw how that common law problem was resolved with the recognition of the doctrine of promissory estoppel in the Central London Property Against the High Trees case, where promissory estoppel came to be that, yes, if you have existing legal arrangement with someone, and under that legal arrangement, the person is supposed to perform obligation towards you, but you go out of your way and you create an impression that you are not going to insist on the strict performance of that legal obligation. And if the person so orders his affairs, later on, you will not be permitted to go back on your word. You'll be precluded, you'll be stopped from going back on your word to say that you never created such state of affairs. And that is what you call an estoppel. And in that regard, there is no need for consideration, as you know already. So let us keep that in mind. And of course, as I said, in talking about promissory estoppel, don't also forget Section 26 of the Evidence Act, which talks about a statement or conduct which can give rise to what? Estoppel. So let us keep that in mind. I think that should suffice for consideration. Okay, so since consideration is related to privity of contracts, let us right away move to privity of contracts. Are there any specific questions you have? Okay. I think someone has a question about promissory estoppel, pre-existing contractual obligation. Okay, Elizabeth, I don't know whether I have addressed the questions. Or they are
Also,
not?
my lord, please, I'm okay.
They're okay
Thank
now.
you.
Okay, good.
Thank you.
Okay, so now let's come to privity of contract. Any question on privity of contract? And as you know, privity of contract can have a question, either essay or problem. I mean, all the topics can be either essay or problem. Yes. Okay, so let's take it this way. If, for example, you have a question which says that so privity of contract is no longer applicable in Ghana. Discuss. Yes. Very simple question, isn't it? Privity of contract is no longer applicable in Ghana. Discuss. Any attempts? Any attempt?
Hello, my lord.
Yes.
Yes, I'll try. Okay, the common law position. That's when we take the case of Tweddle and Atkinson. If you're not a party to a contract, you cannot enforce it. But then concerning the Contract Act 29, I think Section 5, says that if you are a third party and a beneficiary to the contract, irrespective of you not being privy, that means you not being a party to it, you can enforce it. And we have cases like Edward Farms and Harley and Qua Royal Exchange Assurance, Qua and versus Royal Exchange Assurance Limited, I think. So if the question is, it's no longer applicable in Ghana, to a large extent, I will agree to that because any person who is a beneficiary can still enforce it. So it's like almost everybody is a privy to a contract so long as that person it affects that person. So that is how I would say it. Common law says until you are a party, you cannot enforce. But our own Ghanaian Act 29 in Section 5 says that so long as you are a beneficiary, you can enforce it. So the common law position is not working in Ghana at the moment.
Okay. All right. I think I was going to give you a certain scenario, but let's move on. Okay, so thank you very much. Was it Richard who spoke?
Yes, please, my
Okay,
lord.
all right. Okay, thank you. Yeah, so as you rightly said, privity of contract idea is it goes back to consideration. Remember the case of Tweddle and Atkinson. The agreement between two fathers regarding their son and daughter who are about to get married, that they will support them should they marry. They married, and one of the fathers, I think the girl's father, defaulted in paying an amount of money that he had promised to contribute towards their subsistence or their living should they marry. So when the father died, the couple, the son-in-law, sought to sue those who were in charge of the estate of the father-in-law. And a question which arose was whether the son-in-law or even like the couple, whether they were parties to the contract between the two fathers-in-laws. And the court said that yes, despite the fact that they were supposed to be the beneficiaries, they were strangers to the contract because they had not provided, if you like, any consideration and so on. And you also saw how the same principle was actually re-articulated in the Dunlop against pneumatic tie, especially Vican Haldane, how he made like the famous statement regarding privity of contracts, and went back to the ideas of in the cases of Twaddle and Atkins, Darting and Poole and all that, and essentially to make the point that as far as English law is concerned, the general position is that if you are not a party to a contract, you cannot enforce it. You are a stranger to it in the sense that you've not provided any word consideration. However, under English common law, there are some instances where a person who is a stranger to a contract can still enforce it because of certain legal principles or legal devices. So one of them is trust. When you have a trust, the trustee and then the beneficiary. As far as trust is concerned, the agreement which brings the trust into existence is between the settlor, that is a person who has the property and is transferring the ownership or the title to another person called the trustee. So the contract essentially between the maker of the trust, that is the settlor, and then the trustee, for the benefit of the beneficiaries. The beneficiaries are not parties to the contract. So going by orthodox position of the common law, they cannot enforce it. However, equity came in and said that it is against good conscience and all fairness, where the trustee is, for example, dissipating the property, is undermining the property and all that, to prevent the beneficiaries who ultimately stand to benefit from the property from being able to sue upon it, as it were. So equity recognize the right of the beneficiaries to be able to enforce obligations under the contract between the settlor and the trustee against the trustee. So here, you see that an exception has been created at common law to the privity contract. Not only trust, when it comes to agency too, right? Agency. It is also another way of going around the privity rule, because agent, the principal, and then the agent and third parties. Usually, the agent will enter into contract with third parties, and the agent will, for example, make a disclosure that he's entering into the contract on behalf of the principal. Or now, strictly speaking, the contract is congruent between the agent and the third party. Yet, the principal will be able to enforce that contract. In the same vein, the principal will be able to, the agent will be able to enforce the contract against the principal, despite the fact that the principal was not party to the original contract, as it were. So let us keep that in mind. And not only that, when they also come to power of attorney, okay, by reason of the power of attorney to someone who was originally not a party to a transaction, will be able to step into the shoe of the original party and be able to do whatever the original party will have done, still part of like agency. So let us remember that. And then again, when it comes to also assignment, okay? Assignment is an agreement where between the assignor and then the assignee. Let's say typically you have like a contract between A and B. So A decided to transfer his right and obligation under the contract with B to C. Now, so there's an assignment between A and C. And by reason of the assignment, C will be able to enforce the contract against B in the same way that A will have been able to enforce the contract against B. Because by the assignment between A and B, A as an assignor, B as an assignee, B has stepped into the shoes of A, as it were, and will be able to do whatever A will have been able to do against B. So let us keep that in mind. I mean, there are so many other examples at common law. But then, if you come to our Ghanaian law, as our friend rightly mentioned, Section 5 has actually created a statutory solution that where there's a contract and you are supposed to be a beneficiary under the contract, you are named a beneficiary under the contract, then by reason of having been a named beneficiary or falling within the class of beneficiaries so designated under the contract, you will be able to enforce the contract. So let us keep in mind. Okay, as in that should suffice for privity, unless someone has a question on it. Otherwise, that should suffice for privity. Okay, so we move from privity. I think last year or last 2 years, we had a question on the capacity. So I'm sure the students have overlearned capacity and it's very straightforward. Is there anything about capacity that you are still not clear? Capacity to contract. Okay, let's leave capacity. What about intention to create legal relations? Also straightforward. Okay, good. Now let's come to terms. Terms of contract. Anything which you are not clear? So terms here, terms often has got two components. So don't forget terms in general sense and also exclusion clauses or exemption clauses in other sense. So remember that. So any particular question about any of them or any principle there you are not clear, you need more explanation? Okay, so since you're all masters of terms and exclusion clauses, let us move to initiating factors. So let's start with mistake. Is there anything about mistake you need assistance? Anything about mistake you need assistance? Misrepresentation? Or any question from there you want to discuss? Okay, duress. Anything about duress? Okay, I think somebody has put something in the chat. Common mistake and then mutual mistake. Okay. Good. Somebody said that the common mistake and mutual mistake should explain the distinction. Okay, that's a good question. Good. Common mistake and mutual mistake. First of all, they have one thing in common. And what they have in common is that the two parties have all made a mistake. The two parties have all had some kind of like a misapprehension, right? Regarding something relating to the contract. So the two parties have all made some mistake. But then there's important distinction between them. In one case, the two parties have made the same mistake. In the other case, the two parties have made different mistakes. So, common mistake, the two parties have made the same mistake, right? So if you look at the case law, typically what we call like the contract res extincta, for example. Let's say that you make a contract for purchase of grains, right? Let's say you're expecting rice or wheat from Ukraine, right? And it will come through that Russian area. So you've made a contract that you're expecting 1,000 tons of wheat and so on, which I say I have is a ship is on its way from Ukraine to maybe Tema Harbor or Takoradi. But let's suppose that at the time that we made the contract, the grain had actually been blown up by one of these missile strikes going on between Russia and Ukraine, for example. But when you are making the contract, both the offeror and then the offeree were under the clear understanding that the item, that is the wheat or the rice, were actually in existence, right? So the seller, that is offeror, believed and understood that he had wheat or rice. And then the purchaser, the offeree, also believed and understood that the offeror actually had that item. But unbeknown to the two of them, the thing was not in existence. So both parties have made a mistake regarding existence of the subject matter of the contract. And the mistake that they have made is the same mistake. It is identical or common mistake. So that is a common mistake. So that is one thing that we should remember. And of course, if you look at the cases of Kutura and Hester, right? Kutura and Hester, which reflects the hypothetical example that I gave, the position of the law is that where the subject matter of the contract, for example, does not, they made a mistake regarding its existence is not there, then the contract has no basis. And since the contract has no basis, there is no a valid contract between the parties. Mercy, please. Mercy, put your mic off. Mercy, put your mic off. Yeah. Yeah, so let us keep that in mind. But in the case of mutual mistake, right? Both parties have made a mistake, but they have made what we call like a different mistake. And that is why in the literature, sometimes we say that the parties are not consensus addendum. They are at cross purposes. That is to say that the offeror made the offer with a certain understanding or belief. And the offeree also purported to accept it with a different understanding or belief. So what it means is that the sense and the intent with which the offeror made the offer is radically different from the sense and intent with which the offeree purported to accept the offer. And that is why we say that we have like a cross purposes. And if you look at the literature again, where you have a mutual mistake, you don't jump to the legal conclusion unless you apply the objective test of agreement, okay? So the objective test will mean that if you use the position of the official bystander, well, the official bystander will have, for example, understood the, let's say, the offeree who have accepted the offer according to the sense and the intent with which the offeror made it. If the objective test will, for example, say that, then the court will try and give effect to the agreement. The court will not just say that there's no agreement. Now, it is only where the use of the objective test, for example, does not assist the court to come to any consensus in terms of like the objective test, then the court will say that there's no contract, just like the situation in the Raffles and Wichita has. You remember, that is the PLS case. One ship is sailing in October and another one in the December from the same destination, Bombay. Yes, Sam, let's take your question. But before that, the question about mutual and common mistake, I don't know if you are assisted.
Yes, please, my lord. Thank you.
Okay. All right, Sam. Sam, your hand is up. Sam Sachet, or you are just, it's an error. Okay. Okay, so any other thing about mistake? Well, for examination purpose to, okay, let me bring this up. Unilateral mistake as your identity, okay? If you have a problem-based question, especially with respect to unilateral mistake as your identity, and it's not direct, since it's a composite paper you are writing, the facts may also probably support some form of like maybe like a criminal charge or criminal offense, as the case may be. Maybe the offense of like either defrauding by false pretenses, as it were. So, for example, if you have like a hypothetical case, which you can conveniently identify issues from unilateral mistake as to identity of the other contracting party, and you can also have enough information which will enable you to discuss the criminal offense of, let's say, defrauding by false pretenses. I will suggest that don't ignore that. You don't lose anything if the facts before you are enough to support the two issues from the two different areas of the law, from contract law and then from criminal law. Because as I told you, unless your examiner is quite direct and says that identify issues regarding this or that, in which case you have had your scope narrowed. But where your scope is not narrowed, then if the information is enough for you to address the other side that I said, then you must do that so that however the marking scheme is configured, you will be well within it. Any other question on mistake? Okay, misrepresentation. Duress, undue influence. Maybe now that we have what do you call this romance scam, okay? RGR for rare and all those type of things coming up. Maybe we can have like a story around some of these things, and probably either you may have to address your minds to some aspect of misrepresentation, or some aspect of lateral mistake as to identity, as the case may be. But as I said, I am not interested in any particular question. What I'm interested in is that you have a proper understanding of the law, okay? And if you look at how we go about this, you notice that I want you to first have understanding of the principles itself, okay? Once you have the principle, you understand them, then the next thing is you get the authorities with which the principles come, and then you go to the application. So once you have that, you shouldn't be afraid. So you should be able to say that, okay, as far as contract is concerned, any question at all, A to Z, wherever to come from, I have learned enough, understand the law. I should be able to answer it. Even if I'm not going to get 50 over 50, I should be able to get at least 30 or 40 over 50, as it were. So that should be a proper preparation. Okay, so now we are moving away from the vitiating factors to public policy and illegality. Any question from public policy and illegality? Okay, tomorrow. Any question from there? Okay, so if there's no question from public policy and illegality, let us go to discharge of contract, frustration, performance, agreement, and breach. Any question? Anything you are not clear? I think we have exactly, 1 month. I think your exam is on the 8th of September, is that correct? Is your exam on the 8th
Yes,
September?
that's right.
Yeah, so
yes, that's right.
Yeah, so we are just 1 month from your exam day. So 1 month away, anything about these topics which you are not clear, for which you need assistance? Okay, then what it means is that you are preparing very well, which is good. Now let's go to remedies for breach of contract. The common law remedy of damages. Any question? And damages, you have to remember the two aspects: the remoteness of damages and the actual quantification of damages, assessment of damages. Any question about that? Okay, then let's move to equitable remedies for breach of contract. Equitable remedies for breach of contract. Remember, we are talking about injunction. We are talking about specific performance. These are the only equitable remedies for breach of contract. Rectification is not equitable remedy for breach of contract. It's equitable remedy, all right, but it's not for breach of contract, right? It may be useful when you are dealing with maybe some aspect of a mistake, as it were. Rescission is equitable remedy, but it's not for breach of contract. Rescission will be used for when you are dealing with vitiating factors, as it were. Okay, so I think we've reviewed all the topics in contract, unless there is something in particular which you are not clear. regarding how to answer questions in contracts. I think last year I made effort to do a whole tutorial or a whole lesson on it. And I followed it up with even like the PDF on it. So if you go to the, I don't know if I can retrieve the recording, I will retrieve it and then put it on the platform just in case you have missed it. So that just play it back and know the practical support I gave in trying to understand how to answer essay and problem-based question using contract as example. Okay, let me see. I think somebody has something. Okay, so somebody has a question now. Should the IRAC method be used in a case where the problem question provides specific question to answer? Okay, good. So someone has a question that where you have like a problem-based question, okay, in the exams. And at the end of the narrative or the passage, the examiner has, for example, stated the legal issues, right? Or the legal questions, which he or she wants you to resolve. Is it still necessary to stick to the IRAC approach? That is the question. My answer is yes. You'll still use IRAC. The only thing is that because the issues have been stated for you, you don't need to worry your head to now think of the issue because the examiner has actually prescribed the issues for you. But you have to take the issue prescribed one after the other. You state the relevant principles of law and the corresponding authorities, and then you do the application and then the analysis, and then you draw your conclusion before you move on to the other issues set up by the examiner. Okay, so that is how it is. Any other, okay, let me see, there's something else. Okay, I think the same thing has been addressed. Okay, somebody said if you're asked to write a legal opinion, how do you go about it? Okay. In the tutorial that I recorded last year that I'm telling you about, which I will endeavor to retrieve the video, where I talk about it and I made the point that, and even at the last week or so, one of the sessions I talk about it that don't worry your head, okay, about the various stylistics which your examiner may require of you. Write a legal opinion, write a memo, write a brief, write a digest, and all that. Those things are not the main focus, right? The main focus is the meat of your response, the exact material that you are provided. That's what matters. So you are not doing drafting. So the drafting aspect is not really important. What is really important is the substance, okay? So if it's a problem and then you have to write an opinion on all that, you still have to go through the IRAC. If it is maybe, for example, they say that the Law Reform Commission is currently working on reforming or unfair contract terms in Ghana. Submit a memo of your opinion on how the law on unfair contract terms should be legislated and all that. Well, it doesn't matter they say the memo or they say the brief. It's simply an essay question. You still have to go through what we said you should do in an essay question. So let us keep that in mind. Okay, thank you. Any other, before you be drawing the curtain on, any other Okay, so in absence of further questions, we stay away from this area of the law. If I'm to do any contract, I just come with the question and then just discuss that with you. I will not treat any particular topic because the topics have been treated in detail in previous years and the recordings are there. So just go and play them. So have a very good night.
My Lord, please, how do we retrieve the previous recordings? Because some of us didn't get the opportunity to
Okay, so my
attend
advice is that okay, let me demonstrate this thing for you. I'm going to open the YouTube channel and show you how it is done. So just a second, just be on. Okay, so let's say it's like this. Okay, so let's suppose that you go to the YouTube. So let's say, I don't know, like this is my, so let's say you go to your account. You can just, let's assume that, okay, they have like the videos, okay? So when you go, I don't, I wish somebody, okay, so you go to your account like this and then you can just type, let's say consideration, Ghana law, let me see. Okay, so you get a couple of stuff. Let me see how it is. The law of contract. So for example, you see this one, this was last year. This one, for example, we did like about 2 hours discussion of almost everything. You see like the rest. Yeah, so as you go through, you see a couple of things over there. So for example, so this one last year, we did what do you call it? Like a program we discussed and things like that. So that is how it is. But I will endeavor to retrieve some of the links and I will put them on your channel, on your platform for you so that when you click on it, it will take you straight to the particular video, if you cannot retrieve it yourself, okay? All right. On the other hand, if you have like a difficulty, you can also send me maybe a direct request if I have the time. The emphasis is time. If I have the time, then I will. Good evening, everyone, and welcome to. Thank you. So have a good night. Our revision towards